everybody. It is Dean Z speaking to you from Jeffries Hall at the University of Michigan Law School. So excited to be with you here today because I'm going to do a very special Q&A episode. We've had lots of great people writing in with great questions to our email at the admissions office, and a lot of them are questions that are great but are too narrow for a full episode. So I've gathered them together. I hope I didn't miss any. I think I'm going to be able to address them all. But please keep writing because I love getting these questions. So let us get started. If an applicant is well established in the state they're from, but genuinely wants to attend a law school that isn't in their state, how does the admissions committee view such candidates? Will such a strong connection to their home state work against them during the process? This is a very smart question because you're getting into the mind of the admissions office. It is absolutely true that one of the things an admissions office who gets to make choices is going to think about is what kind of fit is this person? Are they going to come? Are they going to enjoy it here? If you are I should clarify too that we're talking here really about schools that aren't national to begin with, right? So schools like Michigan, we routinely get people from 45 of the 50 states. So that this isn't something I spend a lot of time thinking about, but if I were at a school that was much more regional and I got to make choices, I would want to, I would be a little concerned about why does this person want to come here? I would also be thinking though, like, ooh, that's different because mostly I'm getting people from my backyard, so I like the idea of getting someone from somewhere else, but will they come? There are ways to address this in your application materials. You can write about it in an essay, make sure you're very clear about what your connection is to this state or why you are interested in this particular law school and what your career goals are. You could ask if it's a strong enough interest, like this is really your number one school, you could always apply binding early decision, but there are downsides to that, as I've discussed in other episodes, so take that with a grain of salt. You could also ask a recommendation letter writer to put it in their letter. Again, if it is a special enough wish on your part to go there, that it's worth asking the letter writer to write a special letter for that school. So these are ways you can address what might be something that schools will be curious about, is how I would put it. I don't think it's like a mark against you, but it'll be something that they're curious about. And this advice works in a lot of different contexts too. Think about why a school might think you aren't actually interested in them. And if you are sincerely interested, be prepared to explain that and make your case so you allay any concerns they might have. All right, let's move on to question 2. I was wondering if you could share your take on whether those that have been working in a service type profession for a couple years or more and never had experience working at a law firm or for a judge should seek out an opportunity like those for a summer, partially for application purposes. In general, I say don't do anything for application purposes because it's very hard to predict what role a given activity or job is going to play in the decision-making process of an admissions office. So you should be doing the things that you want to do. That said, there's good reasons to seek out that kind of position for your own edification, to make sure this really is the path that you want to walk down. So there's a lot of benefit in it to you if you haven't actually had exposure to the law. If, however, that's not, you're quite sure and you've got reason for being sure that you want to go to law school, I don't think that's necessary. And I think that you can, again, address this in your admissions materials, address your interest in knowledge about the law in your essays, or again, letters of recommendation can fill this role. So you're right that having no exposure to the law might raise an eyebrow for an admissions office if it's not obvious, but if there is some way that you've had connection, or if there's some reason that you're very sure, you can definitely address that. I hope that is helpful. I feel like I'm saying kind of 2 things at once, but I hope you can get the nuances of what I'm trying to say there. All right, let's move on. Okay, I really like this question. It gets at something I think really important that someone is worrying about that they don't need to be worried about. How much does undergraduate institution ranking / prestige matter for a non-traditional student with a good deal of experience after graduating? They go on to explain that they went to what they call a relatively weak undergraduate institution, but did very well there, 4.0, and went on to earn a master's and doctorate. And they say they want to include a short addendum explaining why their undergraduate institution was the best choice at the time, but they're wondering how much that teenage decision will hurt them. I would say for the vast majority of schools, this is not a concern at all. I, in fact, affirmatively love to get people from schools that are, described as relatively weak undergraduate institutions. I don't think of them that way. I think there are just like a lot of reasons why at 18 years old you are making a choice about a college that does not reflect your academic abilities or your ambition at all. It just takes, there's financial concerns, there's family concerns, there's just, at 18, I personally was not fully mature. I don't know about anybody else out there. So I think those choices are entirely explicable and totally fine. I do think that there are a handful of schools out there, peers of Michigan, that, again, get lots and lots of choices, and they tend to prioritize prestigious undergraduate institutions as part of their decision making. So that is true. But that no school just says, I won't look at schools from that aren't an Ivy League school. So you have a shot even for a school that really cares about that. And then the fact that you went on to have a doctorate and that you did so well in undergrad, you have done everything you possibly can, and I just really would not worry about the particularities of your undergraduate institution. And I think that's true even if someone didn't get a 4.0 and didn't go on to a doctorate, especially if it's 10 years ago. But even when it's not 10 years ago, I think there is just a lot of room there for getting a lot of different kinds of schools. And I do not think I am alone in valuing that at law school decision making. So good luck, and I'm glad you asked that. And really, I don't think you should be worried about that at all. All right, here's a quick one. How do admissions teams view applicants who were falsely accused of using AI in assignments in undergrad? So this is, it's a quick one because, like, if you're falsely accused, I don't even think I find out about it, right? Because assuming you were adjudicated to be falsely accused, like there was some professor says, I think they used AI, and then you go for discipline and they say you didn't. But maybe this is a scenario where they feel that they know that it was false, but they got punished anyway. As with all misconduct, you have to explain it. I think in this instance, it's one of the rare instances where there's a good reason to say, this was not true, I have never done this. Sometimes when you say that, it just sounds like you need to stop litigating the misconduct and just move on. But in this case, I think that's worth saying. And I think every sentient being at this point understands that there is no good way to really run an essay through a program and ensure that it is, in fact, AI. Like, the mistakes abound, and everyone knows that. So I think if that is the case, people will be prepared to believe it. If you can get some outside voice, again, a letter of rec writer, to say, I know this wasn't true, that's helpful, because of course it's easy for you as a candidate to say it's not true, and it's, even if I'm inclined to believe you, I can't know for sure one way or another, so it's good to get that outside voice. But again, prepared to believe that accusation will be incorrect, because the stories are legion about how often that happens. Okay, next question is one we get a lot. In fact, a lot of you have asked us to do a whole episode on it, but I don't think it's really a whole episode worth of material. So I just want to try and address some key points quickly. And that is, what's different about the law school admissions process if you are an international applicant? And by international, I mean someone who will need to get a visa in order to study in the United States, as opposed to someone who's a dual citizen or someone who's a permanent resident in the United States. It is different, and for a couple reasons. Mostly it has to do with your job prospects at the end. At the admissions stage, one thing an admissions office might be thinking about is you can't get federal loans, right? So do you seem to understand that, and will you be able to finance your education without getting federal loans? There may be schools that are thinking about that and reluctant to admit because they know you're not good. They are concerned you won't be able to afford it, and that might be a reason why they choose not to admit a given candidate. So that's something that if you feel you know you can afford this, you might want to address that somewhere in an essay, just in a brief addendum. Another reason why it might be a little more difficult if you're an international student is that law school is extremely language dependent, and if you need to have native fluency in English in order to succeed, both in the classroom discussions and in the writing. So if you went to undergraduate institution in the United States, that's very helpful. That would put that fear at rest. Or if you're from an English-speaking country, that fear would not exist. But if you are in a country where English is not the first language, and you did your education there, I think you really need to figure out ways to make sure you are demonstrating your English language ability, because that will be a concern for admissions offices. And then I talked about down the road, employment prospects. That's another thing that an admissions office might be thinking about, because many employers simply will not hire people who need a visa. That's a fairly new phenomenon. It didn't used to be that way, say, a decade ago, but now the visa process has gotten very complex, very expensive, and it is a lottery. So even people who have jobs where it is absolutely important that they hire someone who is not a US citizen, and the employer is really willing to go to the mat for you, it may still not work out. And that we have alumni for whom that has happened to, and they've had to go back to their home country because they can't continue working in the United States. So an admissions office might rightly be concerned about that if they know that your goal is to stay in the United States and work in say, a law firm. So if you aren't interested in staying in the United States, if you want to return to your home country with a JD, you should certainly explicitly mention that. But that's rare, and you shouldn't say it if it's not true, obviously. General, good rule of thumb. But you should recognize that that does make it harder to get into law school, and it has nothing to do with your credentials or your abilities. A school might quite reasonably think, I can take a few people who are going to, need to go through the visa process, because we can, we'll pull out all the stops to support them in their career search, but I can't maybe admit half of the class, right? So those are some of the challenges. And then when you're looking at numbers, I know people have said it doesn't look like you have very many international students at Michigan. I mean, it is a very small part of the pool, frankly. And so, yeah, 2 to 3% is pretty consistently what we at Michigan have had. I think that's probably a pretty typical percentage for many law schools. That doesn't mean that the school is biased against you or doesn't want international students. It is pretty reflective of what the pool is giving us in the first place. I hope that is helpful. Here's another quick one. Senior capstone project. Is it like a thesis? Does it need to be published to be valid? I think what this question means is it as significant to do a senior capstone project as to write a thesis? And my view is absolutely yes, and absolutely no, it does not need to be published in order to be valid. Most of them won't be. Most theses won't be published. So it is very impressive. You should definitely include that you've been able to engage in some kind of like extended major work like a capstone or a thesis, and you should certainly include mention of that in your resume. And it's a bonus point in your favor. Okay. This one is about letters of rec, which I feel like I keep talking about in answers here, so let's talk about them directly. I intend one of my letters of rec to come from a person who is a former professor, coach, and colleague in respective order over the course of 6 years, but also someone who has become my friend over that time. I know that letters of rec should not come from friends, but given the professional nature of our relationship preceded the friendship, would the friendship hurt the credibility of the letter of rec? No, it will not. I think it is, first of all, I don't know that it's even necessary to talk about you being friends in the letter. I don't know that that needs to come up at all, because they'll be talking about you from the point of view of a supervisory role, someone who has been able to review your work, even if you are now peers and friends. So I don't know that the person needs to talk about your friendship at all. But if they do, I just think so long as they clarify, like, this is a friendship that has grown, because of our professional relationship, that's totally fine. They should be clear, though, like, that the friendship is not affecting their integrity, shall we say, in writing the letter. Like, they should be clear, like, I am going to give you the honest, assessment of this person, even though I consider them to be a friend. Here's another letter of rec question. I have heard that many admissions officers are wary of letters of rec from elected officials, in that they are not actually from the official, rather from a staffer with the official's signature added later on. If I do have a letter of rec from my elected official, is the admissions team able to discern a sincere letter from one written by a staffer, or would it be better to opt for a letter from a staff supervisor? I think this question is maybe confusing a few things. I am dubious about letters of rec from elected officials when they are simply that. Like, this person is a constituent of mine, and I think you should admit them to law school. I get a surprising number of those where the official doesn't actually know the applicant, has never worked with the applicant, is simply writing this letter by virtue of the fact that this person voted for them. Or maybe not, he didn't even vote for them, maybe, but just in their district or what have you. That is not a useful letter, so don't ever use that. If you are actually working for an elected official, though, I don't really care how that letter gets written. It's fine if their trusted senior staffer writes it and then they save it. That's sort of between, in my opinion, between the letter writer and their conscience. I assume that they are reading it and that they wouldn't sign something that they didn't think was true. So I personally would never worry about that. But I also feel pretty confident that even if an admissions office is worried about that, no, I don't know how you would tell the difference between a letter that had been written by a senior staffer and signed off on by the elected official and one that was written by the official. So I don't know. I don't think that's something to worry about. Here's a question I think a lot of people might have. It's someone who has been, who graduated about 2 years ago and has had good work since then, but they can't include both their post-undergraduate professional experience and jobs they had during school and still fit it on. I presume they're going for a one-page resume here. And they worry that omitting the school year work will hurt them. And I say, yeah, it will. So I don't think you should omit it. Many schools will accept a 2-page resume. So certainly Michigan does. I know a lot of schools that do. So look for schools that don't put that kind of limit on it. And for those, do as much as you want. For the schools that do say just 1 page, I would personally cut down more on the descriptions of the jobs than I would on the jobs themselves. I think it is very important to show what you did throughout college in terms of your work experience. And I would just try to, I would put the editing in the descriptions of what you've done, and keep that as brief as possible in order to fit as much in terms of variety of work as much as possible on the resume. Here's one that we hear a lot, so I'm glad someone asked it. How much consideration is given to an applicant's degree, GPA, versus the overall LSAC GPA? Is the consideration greater when there is a significant difference and/or an explanation in an addendum? First of all, if there is a significant difference, I absolutely recommend writing an addendum and explaining that. It can only help, so for sure do that. But you should be aware that the GPA that the law schools have to use is the overall cumulative GPA that is calculated by LSAC, not the degree GPA. And it definitely, let's say you started out at one school and you weren't quite ready, and then you take some time off and you return to school, and in the second, go round, you've got a 4.0. The first go round, maybe you had a 2.0. So your overall GPA is a 3.0, and but you ended with a 4.0. That is very compelling and definitely makes a difference that you finished strong. That absolutely will help. But that overall cumulative will also tie the hands of many admissions offices. Even if they think you could do the work, they might think, I don't know if I can, I don't know if I want to be stuck, frankly, with that low a GPA. That might be something that gives them pause from the sheer consideration of medians. But I think as long as you can explain it and show that you've really, got what it takes, you've got the smarts to do it. As I say, you finish strong. You definitely should explain that. And I think in many cases that will carry you over the finish line, even if in not all. But take your shot. Here's a quick one. Does Dean Z read the applications of every person accepted or considering to be accepted to UMich Law? The answer is yes, and beyond that, I read every application. I look at them all. I have 2 other people who look at them first and give me notes, and then I look at them. It is a time-consuming undertaking, but it is very important to me and to the way I do my job. And yes, so I definitely do that. Here's one more. How can reverse splitters boost their application? Well, first of all, I want to say, go on record, reverse splitters, which I understand to mean, it's a term that I think applicants use more than the people who are in the admissions profession. It means someone who has a high GPA and a low LSAT, or a above median GPA and a below median LSAT. At the outset, I'm just going to say lots of schools admit lots and lots of people who are reverse splitters. In fact, all schools admit some reverse splitters. But when you talk about boosting your application, I mean, knowing that someone is just a reverse splitter doesn't tell me enough to tell you how you can boost your application, or even whether it needs any boosting, right? Like, say if you are 1 point below median, you're not, that's just not something any school is going to worry about if you're above median on the GPA. If you are 20 points below median, yeah, then the school might think, I don't know, we care about the LSAT, we think it's predictive. Like, does the undergraduate performance outweigh the lower LSAT enough to make me confident they could do the work here? So that's something to be aware, like that's the concern. In terms of how to boost it, just do your best on every single other element of the application. Put your work into the writing, like really shine there. Let it show your, how good you are at writing and how good you are at thinking. Get good letters of recommendation who will say, this person is very bright. Just put your effort into all the things that you can change, and don't worry too much about the elements that you can't change, namely your LSAT and your GPA. That is good advice for literally all applications. Don't think that your fate rises and falls on your numbers alone, because it just really does not. Okay, this is going to be the last question. We got it very recently. What do I think about the suitability and quality of hybrid or online programs? That's a really good question. I will be very honest and say I don't know a ton about online or hybrid programs. Michigan doesn't have them. So, I'm going to be humble about my ignorance, my relative ignorance in talking about them. I think that could be a really great choice for people who simply can't relocate and don't live in an area where there is a law school nearby, which is many, many people in this country. If you want to go to law school and you can get into an online program and you're not in a position to relocate, you should definitely do that. I would look at the employment outcomes. I would be reluctant to spend a lot of money on an online program, because you will necessarily be missing some elements of the law school process that I think are really beneficial to people. You won't be making great friends with your cohort. You won't be getting to interact with your cohort a lot. You won't have one-on-one the kinds of interactions with professors where you can really get close to people, because it will be all online. But that said, if so I would pay less for that, than for an in-person experience. But I imagine they charge less, so I'm thinking that all works out. I also think that, as I say, I mean, there's only one way to be a lawyer, and that's to get the JD. And you can practice in lots of parts of this country that aren't near law schools. So it makes a lot of sense to me that you might want to go that route if that's your situation. But I do my research. I maybe wouldn't want to start like in the first year of an online program, because I'm guessing there will be some kinks to be worked out. I might want to wait till it's a little better established. But yeah, I think there's a lot of reasons why that makes sense for people. All right, and that is all our questions. I want to wind up, though, with my law-related bonus topic. And it's not grammar again. It's once again from, it's a piece of pop culture that I was reading a book where there is an interaction between a lawyer and a would-be client, where the would-be client is asking for legal advice. And the lawyer says, we have to make this official. Give me $1. Okay, now you've hired me. A lawyer didn't write that book. You don't need to pay someone in order for them to be your lawyer. If that were the case, there would be no pro bono happening in this country. The way to have a lawyer-client relationship where the lawyer cannot reveal your secrets, which is the whole point of having that kind of relationship, is to both parties to have an understanding that you need legal advice and you are relying on the legal advice, and the lawyer is giving you legal advice. It's all about that understanding of what the relationship is. That's what makes the lawyer-client relationship. So don't think when you go to law school and then become a lawyer that you can just go around giving legal advice because, you like to do that on the side, and that you are then protected from being sued for malpractice because you haven't taken money from anybody. It doesn't work like that. You have to be very careful if you're a lawyer about that kind of relationship. So, yeah, so that's how you become a lawyer. And the guy who wrote that in his book, I like his books, but someone should have checked that before it got published. Made that clear. Okay. And that's all I got. Thank you so much for writing in with your questions. I love being able to do these quick hits. I hope it's useful to you. And please keep those cards and letters coming. You can put your comments below. We answer questions there too. Or you can send us emails to law.jd.admissions@umich.edu and put flog in the subject line. You can send either your questions or ideas for full episodes. And yeah, thanks as always to Dustin. Wherever you go, go blue.